The Honorable Peter J. Tober presiding.
Please be seated, everyone. Good morning. Let's go on the record. The State of New Jersey versus Thomas Herbst. This is matter indictment number 2306-79S. We're on for a sentencing and a motion for bail pending appeal. Please have the appearances of counsel.
Good morning, Your Honor. Deputy Attorney General Marian Valietta on behalf of the state.
Good morning, Your Honor. Deputy Attorney General Nicole Sandora on behalf of the state.
Good morning, Deputy Attorney General Diana Bibb on behalf of the state as well.
Good morning, James Ronco Malone on behalf of Mr. Herbst.
Good morning, Your Honor. William J. Hughes, Jr. of the law firm Porzio, Bromberg & Newman on behalf of Thomas Herbst.
Good morning, Your Honor. Sarah Wisniewski of Porzio, Bromberg & Newman, also on behalf of Thomas Herbst.
Thank you, counsel. We have reviewed the various sentencing memorandum and letters in support of Mr. Herbst, also the letters from the victims and their relations. I intend to proceed in the following fashion, hearing first from the defense, then from the state, then any interested parties can address the court if they wish, and lastly, Mr. Herbst can address the court if he wishes. But I'll hear you first if anyone would like to depart from that order.
No objection from the state.
Are there any corrections to the pre-sentence report that I should be aware of?
Your Honor, there's no corrections, deletions, or additions there.
Anything from the state?
No, Your Honor, other than I would just like to note for the court, we have submitted our sentencing brief. I would indicate the only addition that I'd like to bring to the court's attention is that count 1 and count 7, Your Honor, would in fact merge, and that was not noted in our sentencing brief.
Then Mr. Ronco.
Yes, Your Honor. I'm not going to belabor the issue. Your Honor's obviously very familiar with this, having dealt with it for a couple of years now, motions through trial. This was a rather unique case. I don't know if I've ever, in my entire career, defended allegations that were not only a decade old, but 2 decades old, going back 20 years. At times during this trial, I wasn't sure if I was in a civil trial for sexual harassment. This seemed to be sometimes less egregious than some of the things I've dealt with in the civil trials there. I also felt like I was in front of a hearing officer on police disciplinary, or going up to the administrative law judges with regard to the different allegations. I think it is important not to belabor it, but all the official misconduct charges clearly were premised on a violation of administrative policies, from sexual harassment to failure to turn in 1 of 5 badges, through conduct unbecoming, which is basically any actions by a police officer, either in his professional or personal capacity, that could put disrepute on a municipality, can be sufficient to support a criminal conviction. Now, obviously, we don't know exactly what the jury decided. We're not in their mind. As we go through all the official misconduct, for instance, with regard to the allegation about the text messages and Officer Zellog's wife at the time, Mr. Herbst testified that it was a joke back and forth. The officer initially agreed, and he changed and said no, he believed it. I don't know whether the jury believed that Mr. Herbst was really trying to trade an assignment for favors with someone's wife, or if the jury concluded you're the officer who outranks the other officer, and those kind of text messages, whether they're serious or a joke, are inappropriate. Maybe it is conduct unbecoming. Maybe it's sexual harassment. The same thing with the text message about lunch. We don't know what they concluded, but I think it is logical that they took that as a violation of the sexual harassment policy. And the same thing goes for the badge. Apparently the evidence showed that he didn't turn in 1 of 5 badges that was in his car during a motor vehicle stop. Again, potential policy violation. So with regard to the official misconduct, and I'll get to the sexual counts shortly, I think it's relatively clear, at least from my opinion, that the jury believed that he violated these policies. Now, why is that important? As your Honor is aware, nature of the offense is still the #1 driving factor in sentencing. What did the person do? The courts have been very strong on that, and they also talk about, is it slightly above a lesser offense? Is it something that could have been something different? Well, here, any one of these offenses on official misconduct could have been a municipal court case. I'm not even sure if sending a text message would end up being a municipal court case, but it could have been. It also could have been police disciplinary actions, which can result in an officer's being suspended, losing his career. It could also be subject of a civil lawsuit, which in fact it is. So the nature of the offense here, the jury found him guilty of crimes, and that's their right, and obviously we're not retrying that here. But these are so close to strict policy violations that I think when Your Honor looks at the nature of the offense, the conclusion should be this is not egregious. This is really on the low end of offenses that could be filed against police officers in police disciplinary hearings, where we see all kinds of things. So I think if you look at that aspect of it, they're minor. Now I know people are probably jumping up saying, how do you call it minor if you violate a policy? But every day in this state, there are police officers who violate some kind of policy. Every day disciplinary charges are filed. Police officers are in front of municipal boards, they're in front of hearing officers, and we go from there. With regard to the sexual offense, the coercion, which was part of the charge given by Your Honor, very specifically talks about employment and the power within an employee-employer decision. Tom Herbst clearly, at every stage of this, going back to 20 years when the first charge was dated, had a superior position over the victims. He was either a lieutenant or he was the chief during this entire period of time. And I think the jury could have very easily said, look, we don't care whether there was a consensual arrangement or whether this woman was going along with it because she wanted to keep her job, wanted her job to go smoothly, and was in fact coerced. We don't know. Don't know what the jury ultimately was thinking. But it really does kind of go together into a package where you have all these employment-related things with violations of policy, and then you hear about the criminal sexual charges, and again, it's an employee relationship. So I would submit that what we're really facing here is a police officer who violated policy, and he was convicted for it. So when Your Honor is trying to decide where does this fit in the scheme of police misconduct, I would submit it's policy violations. It's not one of the officers who robbed a bank or who was involved in a death by auto, which was recently in front of Your Honor, and somebody passed away. Deterrence is obviously a key factor in anything. If you say, well, all the police officers in the county and state would be watching this, does this deter them any more than the loss of their job? I mean, what can basically deter Thomas Herbst more? Loss of his job, loss of his career, loss of his reputation. And I would submit that the only aggravating factor, as I pointed out, which is deterrence, is not of much weight here, because it's outweighed by the whole loss of the career and the ability of municipal departments, prosecutors' offices to discipline their people in the police disciplinary system. I went through the mitigating factors. I'm not going to repeat that. You then look at who was Thomas Herbst before. Now the state is going to say, well, he was somebody who was committing criminal acts throughout his entire career. And I guess in theory, if whatever picture was shown by the one officer back in, I think, 2002, we don't know what that picture was. Again, we don't know if the jury found that it was to get some kind of benefit, or whether the jury found it was improper, that no superior officer should ever look at any pictures, bikini or otherwise, of any inferior officers. So again, it's that same situation. I think if you look at the law, these are the extraordinary circumstances. The offenses are policy violations. And they're not most of the case law talks about a policy violation where a police officer knows, well, there's a gambling den being run in the local delicatessen, we're going to ignore it. Or someone's dealing drugs, or they're running numbers. And they said, we just ignore it. And that's where they look at police officers and say, well, your job is to enforce the law. And again, not minimizing these violations, because they obviously were found by the jury, and there are other ways they could have been dealt with. But you have to look at them differently than the criminal acts. So I would submit based on that, and more importantly, what Thomas Herbst has done for 30 years, his career. Your Honor has received, I think, 114 letters. I put them all in my appendix. These letters come from relatives, which you would expect, citizens of Manville, other citizens, childhood friends. They run the gamut of literally everybody that would be impacted in anybody's life. And they kept coming, one after another. I'm not going to read them again to you, because I know Your Honor has read them. In my sentencing submission, I did highlight certain ones that I thought deserved to be highlighted. Not to minimize the other ones, but thought it was important to bring that to your attention. So for these reasons, we're asking for an extraordinary sentence here. I'm asking for a straight probation. I'm asking you to downgrade to probation and also waive the 5-year on the official misconduct. I think it's been set forth within my sentencing memorandum. I think it's appropriate. I would not have asked for it if I didn't think there was a chance Your Honor would grant it. And more importantly, if I didn't think there was a chance that an appellate division would affirm it. So for those reasons and what's set forth, I would ask that you, in fact, follow the sentencing recommendation and give him probation.
Thank you, Mr. Howard.
All right, may I hear these?
Yes, Your Honor. Judge, in this case, the state is requesting a sentence that is commensurate with the defendant's conduct for over the course of half of his career. This defendant victimized almost half a dozen individuals over the span of 14 years for over a decade. Judge, to do this, he did it under the authority of his position, his title, and his power. For being Lieutenant and Chief of Police for the Manville Police Department. Your Honor, that conduct for which the state is requesting a sentence, and I know counsel tries to minimize it, is for sexually assaulting his administrative assistant for the entirety of his career, exploiting 2 subordinate officers using his position and power, victimizing yet another individual within the municipal department, and then even when he was stripped of his power, he still abused it. That is the conduct that the state is requesting a sentence for. Judge, and for that conduct, the state is requesting a significant sentence. We're requesting 31 years state prison with 23 and a half of parole ineligibility, all mandatory fines and penalties, registration, and parole supervision for life as required by the statute. Judge, the state does not make this request lightly, and it understands the impact of this sentence. And quite frankly, if the defendant did not want to face such a significant sentence, he should not have been committing criminal offense after criminal offense for over 14 years, for half of his career. Judge, this is not a defendant who had just one bad day. This is not a defendant who had a lapse in judgment amidst a career as a decorated officer. This is just not that defendant. This defendant engaged in a prolonged criminal escapade that was calculated, orchestrated, and furthered by his position as Lieutenant and Chief of Police. So, quite frankly, Judge, when a defendant uses his career, his position, and his authority to commit official misconduct multiple times and sexual assault he doesn't then get to turn around and rely on that same career as a shield to protect him from accepting accountability for his actions. Judge, this is the very last case where a defendant gets credit for being a police officer. Judge, this is not a probation case, which defense is requesting. Judge, how many times do the victims have to watch this defendant walk out of this courtroom? Judge, quite frankly, the law does not allow for probation in this case. The defendant would have to clear 3 legal hurdles in order for that to be a legal possibility. He'd first have to set aside the mandatory minimum. He'd then have to meet the legal requirements to downgrade this, and then he would still, even downgraded, have to overcome the presumption against incarceration. And quite frankly, Judge, there are no facts and circumstances in this case for the defendant to meet that standard. The presumption of imprisonment cannot be overcome, nor are there circumstances to set aside the mandatory minimum in this case. The defense stood here and argued that the defendant engaged in policy violations akin to DP, and still stands behind a version of facts that was presented at trial and rejected. The defendant consistently ignores that he stands before you convicted of 7, but stands before you of 6 serious criminal violations, all but 1 were a second-degree offense. He points to nothing in the record to show that the defendant is so, quote, as required, idiosyncratic that the cost of human imprisonment would amount to a serious injustice that would exceed the need to deter others as required by Jarboe, Evers, and Johnson. Now, the defense has submitted numerous letters in an attempt to paint the defendant in a sympathetic light. But sympathetic is not the same as idiosyncratic, Judge, as required by the law. Quite simply, the letters wrote in support for the defendant are in support of a man that does not exist, that did not present itself during the course of this trial. While there are no facts to support the extraordinary circumstances, there are in fact several facts to justify the maximum sentence on sexual assault and consecutive sentences on a majority of the offenses before the court. This defendant spent half of his 30 years abusing his authority. This defendant was a predator who cloaked himself in a badge and uniform that was charged to protect the vulnerable, not to target them, not to prey on them. And that's what this defendant did. He chose his victims and he targeted them for their inability to fight back, for fear of losing their jobs or for fear of him. He preyed on them. This defendant chose a jury of his peers, and his peers have spoken the truth about his behavior for almost half of his service. And this defendant has earned every single day of the 31 years that the state is requesting. During the course of his career, he's collected over 5 victims in his wake. Christine Bajowski, his administrative assistant for the entirety of his career, Subordinate Officer Ryan Steyer, Subordinate Officer Sebastian Zelag, Municipal Clerk Jennifer Jeremiah, and Ryan Steyer's significant other at the time, Christy Hill. Your Honor, counsel stood here and indicated that these were mere DP violations. What did the person do to deserve this sentence? I know Your Honor heard the trial, I know Your Honor heard the testimony, but I do want to make the record clear. And I do want to tell this court exactly what the defendant did to earn the 31 years. And I want to paint a picture for this court through a timeline of this defendant's service. He joined the Manville Police Department in 1990. He became a sergeant in 2000 and then a lieutenant in 2005. And by 2008, he was abusing his power within 3 short years. Within 3 years of becoming part of the administration of the Manville Police Department, he began abusing his authority. These offenses, again, were not the result of one bad day, a lapse in judgment. The defendant embarked upon a planned, deliberate, and sustained course of criminal conduct for many years. And he waited until he was of sufficient rank to be able to commit these offenses without repercussions. Judge, we heard the testimony that this all began in the fall of 2008. In the fall of 2008, this defendant had Christine Bajowski come into his office. It's at that point that the defendant exposed his penis began masturbating and ejaculated in her hair and on her clothes, and then proceeded to make jokes about it to her in the office. And then years later bragged about it at a Christmas party. Bragging about the conduct, his inappropriate conduct when he called her in order to let her leave early in an impending snowstorm. That is the defendant that stands before you for sentencing. And that wasn't it. That isn't the only reason we're here. Just to shoot a few short months later, this time driving to a training with Christine Bajowski in the front seat and the defendant behind the wheel, again, exposes his penis and starts masturbating. And this time he tries to get Christine Bajowski involved. And when she pulls her hand away, Judge, this defendant makes his disapproval of her action quite clear. Because as you heard the testimony, he stood in that training room and he made it very clear their inequity in power, title, and rank, as he pointed to his stripes and said, "You know who's in charge." He made it clear and he made sure that she knew. Judge, this defendant's conduct then escalated in 2011 into penetration. The details of that encounter, that first encounter in the archive room in 2011, show this defendant's propensity for violence. That testimony paints a very different picture than the consensual relationship that defense was before you and was rejected by the jury. Her testimony was clear. She said no. She said no over and over again inside that archive room. She was forcing down her skirt as he was forcing it up. He spread her legs apart. He pinned her over the cart with his body weight and penetrated her vaginally from behind as he stood there. These details, for which the defendant was found guilty, the defendant stands before you to be sentenced. Not some decorated officer who deserves credit. Not here, Judge, and not in this case. This one act alone would be sufficient to ask for the maximum sentence on count 6 for sexual assault. But unfortunately for the victim, this was not the only act. He did this to her time and time again, over and over again. The defendant assaulted Christine Bajowski over and over. Inside the police department, inside of her home, and in a motel room. So where the defendant tries to minimize his conduct by stating that this was a consensual relationship with a subordinate, and because of the nature of their ranks, the jury found that it was coercion, his fact pattern was rejected by the jury, and his definition of coercion, Your Honor, is inaccurate. He applies a different definition of coercion than that was outlined in the jury instructions. Coercion, as outlined properly in the jury instructions, require the withholding of a benefit or an act that has no other substantial purpose. And I'm summarizing that, Your Honor. His version of events, that a mere consensual relationship between a superior and a subordinate meets that definition of sexual assault, is not supported by the testimony, it's not supported by the law as it was read to the jury, and it is not supported by the verdict in this case. The jury heard the testimony of both force and coercion for the almost a dozen assaults that occurred over that 3 to 4 year span where he was sexually assaulting her over and over again. And quite frankly, Your Honor, force or coercion, one is not more deserving of leniency than the other. Not here, Judge, not in this case. So in 2011 and 2012, as we continue through this defendant's career at the Manville Police Department, when he's at his worst with Christine Bajowski, what does he do? None other than try his luck with other victims. Because it's around this time, at the Far Hills race, where he exploits subordinate officer Ryan Steyer at the time for sexually explicit photos of his then significant other, Christy Hill, in exchange for favorable vacation assignments. This was not an accident. For his own sexual gratification. And who is the woman in the photos? Christy Hill. None other than Christine Bajowski's daughter. None other than the DARE student of this defendant. Judge, as you continue through his career in 2012, he's still not satisfied. At this point, having victimized Christine Brzezowski, Ryan Steyer, Christy Hill, he's still not satisfied. Because it's around this time where he tries his luck with Jennifer Jeremiah. Wear a skirt and meet me for lunch. Her as a victim, asking her to wear a skirt, that wasn't an accident, Your Honor. That was calculating. Because as you recall, at this point in his criminal escapade, he knows the benefit of having his victims wear skirts. Judge, as you continue through his timeline, going up to 2014 to 2015, during this entire time, while he has victimized others, he's never stopped victimizing Christine Brzezowski. But as she found ways to avoid him at work, he started victimizing her in the sanctity of her own home, showing up unannounced, walking in, and sexually assaulting her inside of her own home. And then, when she found ways to make it look like she wasn't at home and he couldn't find her, he started ordering her to motel rooms and sexually assaulted her there. Judge, in 2016, as you continue through his timeline, his predatory nature resulted in yet another victim, Sebastian Zelag. Between October of 2016 and April of 2017, he attempts to exploit Sebastian Zelag for sexual favors from his wife, for shift changes, for references to promotions. Again, not an isolated incident, not just one text message. Talking dozens, over 50 text messages over the course of several days, persistent over and over and over again. It wasn't a joke. He sat on that stand, he said it, and the jury rejected his findings. And then he did it again a few months later. And Sebastian Zelag sat in that witness stand and explained to you his situation. Explained to you his situation as to why he couldn't fight back. Just as Christine Brzezowski did, just as Jennifer Jeremiah did. His victims were calculated. Judge, at its worst for Christine Brzezowski, between the exposing himself, masturbating, and sexually assaulting her, this was sometimes almost a daily, weekly occurrence for her for a prolonged period of time. The defendant felt entitled to his conduct. He owned the victims, he owned the town, and he owned everything in it. He had earned it. He was lieutenant. He was chief of police. Even his suspension did not dissuade him or stop him from abusing his authority. He still felt entitled, even then. So when you view the entirety of the defendant's conduct, his true self is clear. Within a few short years of obtaining power and authority, he started abusing it. And with each year, he became emboldened and his conduct escalated. The record in this case, Your Honor, is devoid of any facts or circumstances that warrant probation in this case. But they do favor consecutive sentences. The state is requesting a term of 7 years with 5 years parole ineligibility on count 1 for his conduct in January of 2021. Consecutive to count 2 to account for his conduct related to Sebastian Zelag. 7 years, 5 years parole ineligibility for that count. Consecutive to 7 years, 5 years parole ineligibility to count 5, which would encompass the conduct for the victims of Ryan Steyer, Christy Hill, Jen Jeremiah, as well as the exposing himself, masturbating before Christine Brzezowski for almost half of his career. And then consecutive to 10 years on count 6 for sexual assault. Judge, separate victims weigh in favor of consecutive sentences as outlined in State v. Molina. Each victim in this case was the result of a calculated decision and predatory instincts because they were in positions not to fight back. Each victim in this case was a wholly separate fact pattern and a separate pattern of abuse that deserves its own sentence. In a case where the defendant victimized half a dozen individuals for 14 years, Your Honor, if that doesn't satisfy the requirement for consecutive sentences, then quite frankly, nothing will. The law is clear. Separate acts on separate victims demand consecutive sentences. Judge, in the absence of a consecutive sentence, this defendant would face the minimum of 5 years imprisonment. This would have afforded him several free crimes, despite the case law that discourages that result. There should be no free crimes. His sentence for the minimum, if he receives 5 years, would be only a third of the length of time that he abused his power, which spanned roughly 14 years. A minimum sentence would mean a 5-year sentence for this defendant, when this defendant had no problem sentencing Christine Wojcicki to almost 14. The structure of the state's recommendation is outlined in the state's brief and is supported after an analysis of aggravating and mitigating factors, which the state will not go through here today, other than to note that the record and the state sentencing submission provide ample room to find aggravating factor 1, 2, 3, 4, and 9. And other than mitigating factor 7, no other mitigating factors apply. An analysis of those factors, as well as the factors outlined in State v. Yarborough, the state's overall sentence is fair, just, deserving, and appropriate. And Judge, for the record, the state's overall recommendation does not change with the dismissal of count 3 and the merger of count 1 or 7. The chief of police in this case is not above the law and does not deserve leniency for committing the heinous acts under the authority of his office while a lieutenant and chief of police. That would be a perverse result. That is not only contrary to the law and the extreme facts of this case, but also a serious violation of the public's trust. The defendant has earned every single day of the 31 sentence asked for by the state. Thank you, Your Honor.
Are there any interested parties that wish to address the court from the state side?
Yes, Your Honor, there are. If I can just have 1 moment. Christine Wojcicki would like to address the court. Your Honor, if you don't mind.
She can sit. Thanks.
Your Honor, I am here today to express the profound pain and devastation I have experienced. As a result of the sexual assaults I endured for many years by my supervisor, Lieutenant and Chief of Police Thomas Herbst, I never imagined I would find myself standing in a courtroom having to explain how someone else's choices ruined my life. My world has been divided into before and after. Before I was confident, I was strong, I was happy, I was independent. I felt safe, I trusted the world around me. I had dreams, goals, and a future I looked forward to. I was present and fully alive, enjoying people, work, and life. After, I was afraid, I felt numb, I was anxious, depressed, and completely disconnected. I spent most days on autopilot, just surviving, not living. I became emotionally shut down, going through the motions to avoid feeling the weight of it all. I lost my sense of worth. I looked fine on the outside, but inside I was breaking. The trauma I endured is something I will carry with me every single day. In 2000, I believed I had started my dream job working at the Manville Police Department. Every day I walked into that building thinking, I can't believe I get to work here. I was proud of the work I did as detective secretary, records clerk, and executive assistant to the chief of police. I believed I was in a safe and honorable place. But that illusion quickly shattered when one officer began sexually assaulting me. He had daily access to me. What started as him sexually gratifying himself while touching parts of my body eventually turned into him raping me. I stayed silent for so long for so many reasons. Fear of losing my job, fear of retaliation against my 2 sons-in-law, fear of not being believed, fear of victim shaming. I didn't want to talk about it because it felt easier to pretend it wasn't happening, but it was happening. And it was destroying me little by little, year after year, causing me so much damage and pain. Being forced to endure this abuse for years was devastating. The trauma wasn't one isolated incident. It was prolonged, persistent, and suffocating. It robbed me of my voice, my freedom, and my sense of self. That kind of suffering runs deep and leaves scars that never fully fade. I've now been in therapy for 3 years. I'm still processing the trauma and trying to heal. I spend a lot of time trying to be normal again. I want to believe things will be okay, but inside I'm still picking up the pieces. I want to feel safe again. I want to go places without constantly scanning the room, anxious and on edge. I want to find joy again in things that once made me smile. Some days I feel like I'm making progress. Other days it feels like I'm right back at the beginning in a dark place I can't escape. I want the court to know that what happened to me wasn't just a crime, but was a life-altering trauma. I ask that justice be served because accountability matters. Thank you.
Thank you, ma'am. Ms. Gallia, any other individuals that wish to address the court?
Yes, Your Honor, at this time, the state will call forward Jennifer Jeremiah.
I began working full-time for the Manville Municipal Court in 2005 at 19 years old. I worked for Manville Court for 10 years until it merged with Hillsborough. I was so young and naive, I had absolutely no idea how the real world worked. By the time I left my position in Manville, I received an education that I never asked for. I learned distrust in law enforcement, employers, and most importantly, in men, especially men in positions of power. When I received those text messages from the defendant, my whole world was changed. I now possess feelings of shame, guilt, and fear that were never mine to carry. When I left Manville Court, I left there with 2 cell phone numbers because I wanted to be able to keep my work life and personal life separate. I never again wanted to feel as though a superior could try to take advantage of me or discredit my work ethic because I rejected their advances. I spent many years walking around with this fear, distrust, and anxiety without even realizing it. I tried to bury these feelings deep down so I wouldn't have to feel them every day. But they never really go away. They stay with you at your next job, in relationships, until one day, if you're lucky, you get the opportunity to do the work to heal them. When I received that phone call from the victim advocate working on this case informing me that I was a victim against the defendant, that day was the beginning of my chance to heal. It's hard to sit with being called a victim. Nobody wants to be called a victim and carry around this new shame and fears of being called one. Fears like, what will people think of me or say about me? When the text exchange happened, I never called myself a victim. I couldn't. I didn't have anyone that I could go to for help. I was supposed to just live with what had happened without the defendant being held accountable for his actions. I was working for a system that was holding people accountable for their actions on a regular basis, but I didn't believe that I had the same right. It's funny how the universe makes us repeat lessons until we learn them. While this case against the defendant was unfolding, I was also experiencing harassment in my job that I was currently at. I wasn't going to stay silent this time, and I made numerous complaints to my HR department. I spent many years working with a therapist on these situations to find ways to move through them instead of around them and to become the best version of myself in spite of them. It's not easy to do the work to heal. It's not easy to sit in that witness box at the front of a courtroom in front of numerous people and tell them your story. Having to relive this uncomfortable and awful feelings all over again wasn't easy, but it was worth it. It was worth it to finally be able to take my power back and to finally be able to accept that, yes, I was a victim of the defendant. Yes, he used his position of power to try to intimidate me into doing something I never wanted to do. Years later, after his arrest, he had the audacity to try to intimidate me at my job, knowing that he was to have no contact with me whatsoever. Will I ever be fully healed from what transpired from the actions of the defendant? Probably not. I will always carry a piece of everything that has transpired from these events with me, but now I can put the weight of it down. It is no longer a silent companion of mine that I... Thanks to the amazing women that prosecuted this case and the amazing women that have supported me through this entire process. I ask you, Judge Stoker, to please take into consideration for sentencing the number of years that I lost in a different kind of prison between 2012 and this year that I will never get back. I ask that you please sentence the defendant to serve a prison sentence that is equivalent to the crimes that he committed. Finally, I ask that you not only consider the years that I have lost due to his actions, but also the years that all of the victims that testified in the trial lost, and all the victims of the defendant that were unable to come forward.
Thank you, ma'am.
All right, this time, the state would ask that you hear from Christina.
While I appreciate a close family and value unconditional friendships and embrace a great support system, after hearing today that 114 letters were sent in to support the defendant, leaves one question on my mind. How was he able to get such people in his life to give such statements? What did he tell them to alter his truth? Do they have daughters or wives that secretly don't want him around? Do they have sons who work so hard in their career to only be coerced by someone that they looked up to, respected, and trusted? Were they present for the 2 weeks when witness after witness and victim after victim came forward to take the stand and show their truth? For those of you that don't know me, my name is Christy Hill, ex-wife of Brian Steyer, friend of Jennifer Jeremiah, and acquaintance of Sibby Seelag, and proud daughter of Christine Bajowski, and now a victim of Thomas Herbst. And here is my truth. Before February of 2022, there are things, situations, and events that I would have never talked about, taken to the grave for lack of a better term. But all of that changed when my mom showed her bravery and courage by coming forward to expose a monster that lives among us. But she was not alone, and this was not an isolated incident. That is why I had to share my truth. Thomas Herbst used his power, his stripe, and his badge to manipulate and control not only me, but his subordinates and members of the community over a period of many years. What was meant to be a private and intimate moment between me and my then husband was turned into something else entirely by the hands of the defendant. Demanding explicit photos of me, he used as a bargaining chip, pulling his rank and authority over one of his officers, which was then used as permission. Permission for him to show up at my job and expose himself, request sexual favors. Is this how an officer of the law should be conducting himself on or off duty? The way I see it is, if you are the law, you should have a higher standard to withhold the law. How many people in his career has he arrested, sent to confinement, charged for the same heinous acts of crime that he himself committed? The answer should be countless. That was the oath he took when he became a police officer to protect and serve. Who was he protecting? Not us, not the victims who came forward to expose the truth of who Thomas Herbst really was. Those pictures of me that were demanded by the defendant for his own personal gratification were ironically shared for vacation, for time off, so that we can enjoy ourselves. Thomas Herbst has been enjoying his vacation for the last 6 months, not us. The person he pretended to be, the values he claimed to uphold, they were a lie. I stand here today with the other victims who had the courage to speak out and relive the most private, painful, humiliating, and darkest moments of their lives. We deserve justice, to live our lives without constantly looking over our shoulder of retaliation, while our monster is out there enjoying beaches, barbecue, and sunshine. The expectation is that his sentencing will reflect the deep damage he caused in so many people's lives. Justice is not just a word, it's an action, and the truth was revealed because of the true men and women in this room who showed bravery.
Thank you, ma'am. Does the state have any other people who would wish to address the court?
One moment, Your Honor. Anyone else wish to speak? Yes, Your Honor, if we can have this side. State your name.
Hi, my name is Jay Wojcicki. I'm the daughter of Christine Wojcicki. Pride and honor should have come from simply serving as police chief, but for Thomas Herbst, that wasn't enough. He filled the void in himself with intimidation, humiliation, and abuse of power. He used his badge not to protect and serve as he had sworn, but to harm and to gratify himself at the expense of others. That power ended when my mother, the one with the true strength and honor, came forward. We thank the court for returning a guilty verdict. Now finally, Judgment Day has come. Your Honor, we are asking for the safety of every person affected by Thomas Herbst and for the integrity of justice that he be remanded in custody immediately upon sentencing. Herbst has already been granted the privilege of multiple postponements and freedoms he did not deserve, while his victims have lived with the consequences every single day. He has shown no remorse for the harm he's caused. Every extra moment that he walks free is another moment at risk, another reminder of the power that he once abused. Justice demands that today be the day his freedom ends. No more delays, no more privileges. Today is the day to grant the victims the closure they have earned and the finality that they deserve.
Thank you.
Anyone else wish to be heard? That's it for the state, Your Honor.
Thank you, Ms. Gallienda. Mr. Ronco, did your client wish to address the court?
Yes, Your Honor.
Thank you, Your Honor. I stand before you today as a man who believes. My whole life has always been, and I believe, to achieve whatever it is you set your sights, your mind, and your goals should be your top priority, whether it be personally or professionally. You put your mind to it, you dedicate yourself to it, and you take pride in the path that you have chosen. There are values that were instilled in me by my parents who are in the courtroom today. I believe in those values. I've stood by those values, and I've passed those values on to my kids, who are also here today. Believing in yourself and dedicating yourself to your family and your friends and your work is who I actually am. That belief extended into my professional career, the life towards the judicial system. And for 32 years, I believed, and I currently believe, in the judicial system. I was fortunate enough in my career to make many friends, forge many friendships, and have a very rewarding career serving the citizens of Manville. From saving lives in CPR to dragging an elderly man from a burning house and saving his life are just a few things that come to mind. During those 32 years, during those 32 years were times when you felt very proud for yourself, your family, and your coworkers. Unfortunately, during those times, officers do make mistakes. And when I say mistakes, I mean a mistake of the heart, not of the mind. The system is built to handle these mistakes if you do make a bad decision. The belief is to address the issue, dole out the punishment if and when it is necessary. And the goal is to make the officer yet another productive member of the department, and not to solely punish him and ruin his career and or his life and that of his family. I stand in front of you here today, Your Honor, to advise you, this court, as well as the people in it. I personally, or under the color of my office, have never, ever attempted, demanded, threatened, or forced any female in my life for sex and or sexual favors. My mistake, and I reiterated today, I said it at grand jury, and I said it at trial. I entered into a consensual affair. That's a mistake that I made, and something I have to live with personally. Telling my wife and my 2 kids what I did and how I went against my marital vows is something that was the hardest day of my entire life, and something I have to live with personally. As far as sending text messages, sure, I did. I made a mistake to a friend and a coworker, talking about lunch, making some joking comments. Should I have done it as a supervisor? In hindsight, probably not. A text message, a mistake, not a criminal offense. My life has been ruined by a consensual affair, which I own up to. Somehow evolved into criminal charges, civil litigation, losing my job, my pension, my ability to obtain gainful employment, as well as having my family dragged into something they didn't deserve. Now they want my freedom. I said in the beginning of the statement, I believe, and Your Honor, I still do believe in the system, as I've spent more than half of my life enforcing it. Thank you.
Rocco, is there anyone else on behalf of your client?
No, Your Honor.
Anything further from the state or defense before the court pronounces the sentence?
No, other than the state would like to mark as sentencing exhibits its brief submission, as well as the victim impact statements of Christine Brzezowski, Jennifer Jeremiah, and Christy Hill, Your Honor.
I have those three statements. What was the first thing you said?
The state sentencing brief, Your Honor.
I'll mark the defense sentencing brief as well. I have all the letters. Anything further before the court does sentence?
No, Your Honor.
All right, then the court will impose sentence as follows. Mr. Herbst was originally charged in the indictment.
Sorry, do you want to stand? Do you want to sit?
He can remain seated. All right. He was originally charged in the indictment, 2306-79S, with 8 counts. Official misconduct in the second degree in count 1, official misconduct in the second degree in count 2. In count 3, he was charged with official misconduct in the second degree, but was acquitted pursuant to the court's decision of June 19, 2025. Count 4 was official misconduct in the second degree. Count 5 was pattern of official misconduct in the second degree. Count 6 was sexual assault in the second degree. Count 7 was dismissed by the state prior to trial of sexual assault in the second degree, and then what was initially count 8 became count 7, criminal sexual conduct in the fourth degree. Again, prior to the trial, the state voluntarily dismissed count 7. Count 8 therefore became count 7 for the purposes of trial. The parties proceeded to trial on January 27, 2025. The jury returned a verdict on February 13th, finding the defendant guilty on all charges. On April 18, 2025, the defendant filed a motion for judgment of acquittal, and in the alternative, a motion for new trial. The court granted the motion in part, acquitting the defendant on count 3. The motion was denied on the remaining counts, and the motion for new trial was denied in full. Per its sentencing memorandum dated May 22, 2025, the state submits that the court should sentence the defendant to a cumulative sentence of 31 years in a New Jersey state prison with a 23.5-year period of parole ineligibility. Specifically, the state requests the following as to the official misconduct counts 1 through 4 and the pattern of official misconduct count 5, that the defendant should be sentenced to the presumptive 7-year term in state prison for each of those counts. Counts 1, 2, and 5 should run consecutively to each other because each count involves different victims or acts for a period of 21 years imprisonment. Counts 3 and 4, which do not involve different victims, should run concurrently to one another and to the other counts. For the sexual assault count, count 6, defendant should be sentenced to a 10-year term in state prison subject to the No Early Release Act to run consecutively to all counts for a total cumulative sentence of 31 years. Last, as to this criminal sexual assault, count 7, the state argues that he should be sentenced to 8 months imprisonment running concurrently with all other counts, and the court should assess all appropriate fines and penalties. In response, the defendant submitted a sentencing memorandum on July 18, 2025. In that memorandum, the defendant asked the court to do the following: waive the mandatory minimum of 5 years parole and eligibility on counts 1, 2, 4, and 5, downgrade all counts 1, 2, 4, 5, 6, and 7, and sentence him in this third-degree range, and ultimately sentence him to a term of non-custodial probation for the reasons set forth in the defense submission. The facts of this matter are as follows. On July 12, 2023, the state grand jury indicted the defendant, Thomas Herbst, on 8 counts relating to his acts he committed while working at the Manville Police Department as a ranking officer, including the chief of police. Count 1 charged him with official misconduct for placing his hand in the victim's shirt and touching her bare breast. At the time, the victim was his secretary. Count 2 charged him with another violation of official misconduct for texting another victim, SS, about having relations with SS's wife. The state alleges that the defendant conditioned favorable employment action, namely SS's request not to be placed with a certain supervising officer, on the defendant securing the non-pecuniary benefit of having relations with SS's wife. Count 3, charged him with a violation of official misconduct for using his Manville Police Department assigned desktop computer to secure a personal benefit by accessing sexually explicit images and videos on more than one occasion. Count 4, charged him with a final count of second-degree official misconduct for failing to turn over a police-issued badge and displaying that badge and representing himself as the chief of police during a traffic stop on January 10th, 2023. Count 5, charged him with a second-degree pattern of official misconduct, which requires him to have committed 2 or more acts of official misconduct, incorporated the acts alleged in counts 1, 2, 3, and 4 as separate instances of official misconduct in furtherance of this charge. The state alleged he committed 4 other acts that would support this charge, that he sexually assaulted and penetrated KB numerous times from 2008 to 2015, that he requested a sexually explicit photograph from the victim RS of his then wife, victim KAH, in exchange for a favorable scheduling assignment. Subsection G alleged that he exposed his genitalia to KAH and asked her to touch it while representing himself in a professional capacity at her place of employment. And finally, subsection H alleged that he texted another victim, JJ, to wear a skirt and meet him for lunch the next day. Count 6 charged him with second-degree sexual assault for committing 1 or more acts of sexual penetration. Count 7 charged him with second-degree sexual assault for committing 1 or more acts of sexual penetration against the victim by using physical force or coercion. That count was dismissed prior to trial. Count 8, now 7, charges him with 4th-degree criminal sexual conduct for using physical force or coercion to commit sexual conduct against KB in the aforementioned 2021 incident. The defendant has no identifiable juvenile court history, has no prior arrests, he has no convictions as an adult at the municipal, family, or superior court levels. This present offense is his first indictable conviction. He's a 57-year-old married male who lives with his wife and children in Bridgewater. He's currently employed with the union and previously worked for the Manville Police Department for 32 years, most recently holding the title of Chief of Police prior to the present offense. He has a bachelor's degree in law and justice, graduated from the Police Academy and the FBI Academy. He reports good physical health. Pursuant to the statutes, he was examined at the Adult Diagnostic and Treatment Center on March 18, 2025 by the psychologist Andrew Greenberg. In accordance with the statutes, the doctor indicated that he is not eligible for sentencing under the purview of the New Jersey Sex Offender Act. He's entitled to 1 additional day of jail credit for the evaluation at Avenel on March 18th. And he had another day for which he's entitled to jail credit. That was on April 12th, 2023. Now, under State v. Yarbo, this court has a duty to look at the individual offender and balance aggravating and mitigating factors to determine a proper range of sentence. These aggravating and mitigating factors are utilized to ensure that a sentencing is individualized without being arbitrary, and they ensure that the sentence imposed is tailored to the individual offender and the particular crime that he or she committed. That's State v. Saints, 107 New Jersey, 283-289, 1987 decision of our Supreme Court. The state has requested the following aggravating factors: 1, 2, 3, 4, and 9. 1 talks about the nature of the and circumstances of the offense and the role of the actor therein, including whether or not it was committed in an especially heinous, cruel, or depraved manner. This factor is often a challenge for the court, as it has to be careful that the conduct charged is not incorporated in the elements of the statutory offense. Factor 2 that the state requests the court apply is the gravity and seriousness of harm inflicted on the victim, including whether or not the defendant knew or reasonably should have known that the victim was particularly vulnerable and incapable of resistance due to advanced age, ill health, or extreme youth, or for any reason was substantially incapable of exercising normal physical or mental power of resistance. There's also a request for factor 3, the risk that he'll commit another offense. A request for factor 4, that a lesser sentence will depreciate the seriousness of the defendant's offense because it involved a breach of the public trust. And number 9, the need to deter him and others from violating the law. The court has analyzed the factors in the statute, has read the party's sentencing brief, and certainly am very familiar with the facts. I presided over the trial. I listened to the victim's testimony today. I've read the victim impact statements. I'm constrained to conclude that aggravating factors 1 and 2 are subsumed in the elements of the charged. I mean, the defendant's view of the case is that there was a consensual affair that was criminalized. The state's view of the case is very different, that this was a pattern pervasive throughout his career, that it was really part and parcel of the way he did his job. And they asked for a significant sentence, 31.5 years, which is more than the court has often imposed in homicide cases and manslaughter cases, so it's asking for a very serious sentence. I think all told, the elements of the offense incorporate these aggravating factors. I do find, of course, that aggravating factor 9 applies, the need to deter him and others from violating the law, especially in the role that he served for the public. But I don't find that any of the other aggravating factors apply, and I only apply factor 9. As mitigating factors, the defense has asked for 6, 1, 2, 7, 8, 9, and 10. Number 1, that his conduct caused or threatened serious harm. The court rejects application of that factor. It's clear that his conduct caused serious harm to these victims, as demonstrated throughout the trial, throughout their statements today at sentencing, and throughout their letters. That he did not contemplate his conduct would cause or threaten serious harm. I reject that factor as well. I mean, certainly, even taken in a view as most favorable to the defendant, he had to know that his conduct would have had some impact on these victims that would cause them harm. And the court rejects outright the application of mitigating factor 2. I do apply factor 7, and the state does not contest it, that he has no history of prior delinquency or criminal activity. Number 8, the result of conduct, that the defendant's conduct was the result of circumstances unlikely to recur. That one is always difficult for the court. For any defendant, it's almost impossible to predict how involvement in the criminal justice system, a trial in some cases, sentencing in many cases, probation or incarceration is going to change them in a way that circumstances would unlikely to recur. The state would assume, vehemently disagree with the application of this factor because the multiple victims. The defense, on the other hand, would say that there's only one victim here, it was a consensual affair, thus the circumstances are unlikely to recur. But the court, on balance, rejects the application of that factor as a mitigating one. I do accept factor 9, the character and attitude of the defendant indicating that he's unlikely to commit another offense. So the court will apply factors 7 and 9. I've been asked to apply factor 10, that he would respond affirmatively to probationary treatment. I'll talk about that at the conclusion of the sentencing. All told, I find that the mitigating factors slightly outweigh the aggravating factors. On the indictment, the presumptive, these are sentences in the second-degree range. The exposure is 5 to 10 years in the New Jersey State Prison. Defense has asked for a downgrade from the second-degree range to the third-degree range. In order for the court to do that, the court must find under NJSC 2C43-6 that now, it's a different statutory section. Nonetheless, I have to find that the mitigating factors substantially outweigh the mitigating factors. I haven't found that. So to downgrade to a third-degree sentencing is inappropriate in this court's eyes. On count 1, charging official misconduct in violation of 2C30-2A in the second degree, the defendant is hereby sentenced to 7 years in the New Jersey State Prison. The request for a non-custodial probation and a waiver of the mandatory term and a downgrade to the third-degree charge is rejected. On count 2, charging official misconduct in the second degree, 7 years in the New Jersey State Prison. Count 4, charging official misconduct, also 7 years in the New Jersey State Prison. Count 5, 7 years in the state prison. Count 6, charging sexual assault in the second degree, 7 years in the state prison. I'll talk about the concurrent consecutive run in a moment, but on count 7, charging criminal sexual contact, which is a fourth-degree charge, the state has requested 18 months. Defense requests non-custodial probation. This court will sentence the defendant to 1 year in the New Jersey State Prison. They'll provide a DNA sample, pay the cost of same for the 6 different charges. There are a total 75 times 6, $450 for safe neighborhoods, $300 for violent crimes, $30 for law enforcement officers training, a $1,000 maintenance law penalty, a $30 sexual offender monitoring penalty, an $800 sexual assault nurse examiner's program penalty, a $100 sex offender surcharge with a $1 transaction fee. Those fines will be payable to the New Jersey Department of Corrections. He's entitled to 2 years of jail credit for the period I've just identified. Any open warrants are vacated, bail is discharged. Now, the state has requested that I run these sentences concurrent. Defense has requested, of course, non-custodial probation. To really run a sentence concurrent, the state's essence of the argument is that there's no free crimes, that there are multiple victims here, and that I should run them all concurrent. And almost every day we come into this courtroom, and the consecutive sentence is a rare one. If I said concurrent before, I apologize. I meant the state was arguing for consecutive, and the defense argues for concurrent. The consecutive sentence is a rare one. There really has to be something along the line of 2 murders, 2 something like that. I understand that these are 4 different victims, and they're very different situated in the pattern that the defendant has allegedly engaged in. Supports the state argument for consecutive sentences, but I don't think it's appropriate here. I'm going to run all these sentences concurrent. It's 7 years in the state prison on the 2nd-degree charges. It's 1 year in state prison on the 4th-degree charge. He has 5 days to appeal this sentence. If he can't afford an attorney, one can be appointed by the court. If he misses the 45-day deadline, he can ask for a 30-day extension to file his appeal if he shows good reason for missing a deadline. If he misses the extended deadline, he might lose his right to appeal. You have 5 years from today's date to file a petition for post-conviction relief. Mr. Herbst, I have here a form that notices those appeal rights and petition rights. Did you go over that with Mr. Ronco and sign it?
Did.
There is also a sentence that this court has imposed that pursuant to NJSA 2C:43-64 that I'm sentencing you to parole supervision for life. You'll be under the supervision of the Division of Parole of the State Parole Board. You have to report immediately in person to the designated parole board office in New Brunswick once the sentence, the custodial portion of the sentence is completed. Any clarifications or corrections of the court sentence from the state?
Yes, Your Honor, I would. I know you're indicated that the defendant is entitled to 2 years of jail credit. That's 2 days of jail credit, correct?
I said year credit, but it's usually not that little. Yeah, 2 days.
And then also, Your Honor, I would note that count 1 and count 7 should merge.
You said that and they should.
And
the record in the JOC will support that.
Perfect, thank you, Your Honor. Additionally, Your Honor indicated the sentences is Your Honor implying the mandatory minimum of 5 years for each of those as required by law?
I don't see how I go over 5, and that's really, I should have articulated that word in my
Thank you, Your
sentence. In order for, and the state briefed this well, and it's probably not afforded the benefit of that perhaps, but in order, not only does this court have to find that the mitigating factors substantially outweigh the aggravating in order to go down to sentencing grade, this has an additional hurdle. There's a mandatory minimum 5-year sentence for crimes of the listed crimes in the statute, and sexual assault is one of them. So for the court to downgrade below that, as is official misconduct, so for the court to go beyond that mandatory minimum would, in this court's mind, be reversible error. All right, Mr. Ronco, any corrections from the defense?
No.
All right. Then the parties wish to be heard on the motion to stay the custodial portion of the sentence.
Yes, Your Honor, William J. Hughes Jr. on behalf of the defendant. We have filed a motion for bail pending appeal. We have extensively briefed it in our moving papers and in our reply. We respectfully submit that there is a substantial question. Pursuant to New Jersey Supreme Court law, that means that there is a novel issue that has not been raised before, not decided, or that is fairly debatable. In this instance, we believe, and we strongly contend, that the issues relating to the official misconduct charge themselves may be constitutionally deficient pursuant to the New Jersey Constitution and the U.S. Constitution, in that each of those charges are based upon a municipal administrative policy or regulation. And what that does is it essentially places the power to define the parameters of what a crime is in the hands of a municipal employee. That violates separation of powers. And federal courts have often spoken of this, and Your Honor was referenced Carter v. Wells Bowen Realty. Also, Justice Scalia, before his passing, referenced the ability of essentially government bureaucrats to define the parameters of crime. That's not the job under the Constitution, both in the New Jersey Constitution and the U.S. Constitution, but particularly in the New Jersey Constitution. It's the job of the legislature to define the parameters of what constitutes criminal conduct and then assign a penalty to that conduct. Now the state's going to argue that this has been raised before, but this particular issue has never been raised or put before the appellate courts before, as to whether or not a municipal policy can define the parameters of criminal conduct. And there are all sorts of notice provisions. We submit that it is repugnant to any conviction. And Your Honor implicitly recognizes in dismissing the convictions for the pornography, saying, well, it's not readily apparent that this conduct in and of itself would be rendered criminal conduct. Well, at this point in time, what conduct in a municipal manual for any municipal employee, whether it be a police officer or a clerk, knows which violation will render their conduct to be criminal? And that is the issue that we intend to put before the appellate division. Now, we still have the issue relating to the sexual assault by coercion, and what we submit with that is that the jury was instructed that it could find the defendant guilty based upon two different theories. Under established law, the defendant is entitled to know which of those theories he's being convicted of. And I'll liken it to, for instance, where you have a conspiracy charge, and a conspiracy charge has several objects of the conspiracy. Well, the jury has to be unanimous on which of those objects they're convicting on. And on top of that, we would submit, and we will submit to the appellate division, that that with all of the influx of the improper information relating to the official misconduct charge, kind of poisoned the well when it comes to the sexual conduct. We believe that these are substantial questions, and the statute is written. It says that that the court shall, it's not may, it says shall, grant bail if there is a substantial question, number one. Number two, the defendant does not pose a risk of flight, and number three, is not a danger of risk to the community. Now, with respect to the first one, I've outlined what our position is on the substantial question. With respect to risk of flight and danger to the community, we submit that the defendant is neither. Number one, he's tier one. He's at the lowest level of monitoring up until this point. He has been compliant. He has significant ties to this community. He has a strong interest in vindicating his name and his reputation. Number two, with the danger to the community. Well, the prosecution's theory is that the touchstone of this defendant's weapon was his office. Well, he's not in office, right? He has no ability to commit the crimes under the prosecution's own theory. So he is a danger to no one. Now I understand that the state has an interest in seeking this. We have an interest seeking immediate incarceration. We have an interest in making sure that this is being done right. Understand that the facts and circumstances of this case are very charged, but the legal issues are very substantial, and they have far-reaching consequences throughout the state. And indeed, how OPIA, and how OPIA operates, the Office of Professional integrity and public integrity and accountability, and how they operate. That's an important question that we submit will be before the appellate division. Thank you, Ron.
Who's arguing?
I am. As Mr. Hughes stated, defendant needs to show 3 requirements: that he does not pose a danger to others, that he's not a flight risk, and that he has a substantial question for his appeal. The state maintains that he has not demonstrated any of these things. At the outset, as the state argued at the close of the jury's verdict, defendant poses both the danger to the victims in this case and a risk of flight. As to flight risk, the calculus for his flight has never been clearer. The court has now imposed a sentence of incarceration of 7 years with 5-year parole and eligibility. This motivation has not existed until this time, and he should not get credit for doing the things that he was legally required to do during his release, pending trial, and pending this sentence. As to a danger to the victims, to ignore the conduct in this case, he is convicted of sexual assault, and not just one instance of sexual assault, but multiple instances, including going to a victim's house, a house that he had no qualms being pulled over near after he was charged by complaint summons. And then it didn't stop there, because after he was indicted, he had no problem having contact with another victim in this case. And while that contact may have been incidental, his lack of appropriate action in avoiding her is telling. As to the substantial questions that counsel argues, I'd first like to address the issues as to official misconduct. This issue is identical to the issue to the court was grappled with in Thompson, which this court is very familiar with, in that a policy violation can be a basis for official misconduct, because the crime of official misconduct is satisfied when a public official has committed an unauthorized act for a purposeful benefit. As the court in State v. Parker said, nothing requires that the underlying act be criminal. And in fact, this issue was later, the court's holding as to the notice issue in Thompson, the appellate division later clarified in an unpublished case, State v. McConney, which I have a copy of if the court wishes to see it, in which the appellate division clarified that Thompson does not stand for the proposition that a violation of an ethical code applicable to an employee by statute or contract cannot demonstrate the employee engaged in an unauthorized act. This issue is far from novel. It comes up in official misconduct cases all of the time because public servants refuse to acknowledge the second half of the official misconduct statute, which is that it is a knowingly unauthorized act for a purposeful benefit. And as this court has reviewed both at the motion to dismiss stage and at counsel's motion for judgment of acquittal stage, those elements were satisfied here. This is not a novel issue. In his moving papers, although he didn't address it here, counsel also argues that his conduct was not related to his office. Again, this is not a novel issue. There are a litany of cases in which courts have grappled with whether or not a public servant's conduct relates to their office. Again, this is not a substantial issue. It's not something novel. It's not something that could be fairly decided in the defendant's favor. As to the coercion jury instruction, counsel argues that the court's failure to say a conjunction between the two definitions of coercion is an error so egregious that it confused the jury. The jury instructions here, though, when considered as a whole, did not create a genuine risk of jury confusion. They tracked the model jury charges, and a natural reading of the sentences without the or would have led the jury to the conclusion that the state needed to establish both of those definitions, which is a heightened standard from which the defendant would have benefited. To the extent he also argues that the jury needed to be specifically unanimous as to which definition of coercion it believed was applicable to the defendant's conduct, no such specific unanimity instruction was requested because it wasn't required. As the court in Scherzer discussed, the jury did not have to be specifically unanimous as to the acts of sexual penetration that they found. As this court then further explained, the jury also did not have to be specifically unanimous as to whether or not it found force or coercion. It's unclear how you can get 3 steps deep into that analysis where you don't require the 2 preceding issues, but then you would require the jury to be specifically unanimous. Further, specific unanimity is only required when different theories are essentially contradictory. Here, the theories were conceptually similar, and the jury heard evidence that would have satisfied either of the definitions. Regardless of all of that, even if the court perceives these issues to be substantial issues, bail is still not warranted because he has not raised a substantial issue as to every count for which the court has imposed imprisonment. Because these issues do not truly affect count 2, which is the text messages related to Sebastian Zielag and his wife, and count 4, which is the traffic stop incident where defendant improperly retained and displayed a badge. To the extent that counsel now argues that there was spillover prejudice, there's a presumption the jury follows the court's instructions. The jury was instructed to consider each count separately, and we have evidence that the jury did just that because they acquitted defendant of the conduct under count 5G. Ultimately, defendant has not satisfied any of the requirements for bail pending appeal, and the court should not grant his release pending disposition of his direct appeal.
Yes, Your Honor, a couple of things. Number one, on Thompson, as counsel well knows, this was a regulation, a ethics code regulation applicable to New Jersey State Department of Treasury, and in that case, the specific issue of separation of powers was never raised. You know, additionally, as I believe as counsel well knows, when the defendant was pulled over and on the badge incident, he had his daughter in his car, and they were on their way to pick up a vehicle. Now, in the issues, quite simply, have not been raised before, and I understand and appreciate the zealous advocacy of the state on this issue, why they would not want to face this issue, because it is substantial, and the law, if you take a look at the survey throughout the country, is looking a different way. But we submit that that under the current standard, that bail is appropriate in this case and should be granted. Thank you, Your Honor.
Before I decide on the motion, I neglected to raise the issue of the No Early Release Act. It's only applicable to the sexual assault, not to the 4 official misconducts.
That's correct, count 6.
Defense wish to be heard on that?
No.
Right, so the sentence should incorporate that the provisions of the No Early Release Act, which requires a defendant to serve 85% of the sentence before being eligible for parole. That sentence was 7 years. That'll be incorporated in the judgment of conviction.
Thank you.
The court is required to do so. All right, on the motion, defense has filed a motion for bail pending appeals. As the parties have eloquently and forcefully briefed, the court has to find a variety, really 3 things, in order to grant such a motion, and can dispense with what I view as the easier of the 3, the risk of the defendant's flight and the danger to the community. I don't think that the defendant would pose a risk of flight. I understand the state's argument that he's facing, but he's lived here all his life. He's family here, he has community here. I don't think that he's likely to flee, and moreover, I don't think that he would harm the second part, that he'd be a danger to community. The real issue and the focus of this court when the motion was filed was, is there a substantial question? And under federal laws, as cited in the state's brief, the state turned to federal law because it found that the New Jersey Supreme Court found federal case law instructive in State versus Robertson, 228 NJ 138. The appeal has to raise a substantial question of law and fact, or fact, likely to result in reversal, order for a new trial, a sentence that does not include a term of imprisonment, or a reduced sentence to a term of imprisonment less than the total time already served. Well, he hasn't served any time other than those 2 jail sentences, so the 4th prong of that test is moot. The first 3 is what the court has to look at, and it's been characterized by the defense as criminalizing a municipal ordinance. I think it's more than that. And the state argues that. It's a charge. You may disagree with the jury's verdict, which every defendant has the right to do, but this jury found that he sexually assaulted the victim. The crime, the activity in the after 2 weeks of trial, should know exactly the records room and the file room where the victim, and I apologize for raising the facts again in a rather profound way, but I think it's necessary to protect the record by bending her over the table and having sexual relations with her. They found that the defendant committed that act, and court has sentenced him to a mid-range sentence on the second degree. I don't think there's anything unique, novel about that. The court dismissed the charge of viewing pornography on the computer on one Wednesday before Thanksgiving because for the reasons stated in its decision. But that doesn't bootstrap the court's decision on the other crimes that the jury found the defendant guilty of beyond a reasonable doubt, and that is demanding pictures on a cell phone in case for a favorable assignment, asking another employee to meet him for lunch and wear a skirt, and the other charges that involve the principal victim, in this case, KB. So for those reasons, I don't think there's a novel, unique enough question raised, certainly on the sexual assault count, that would mandate, encourage the court to stay bail, to issue a bail pending appeal and grant the defense's motion. So that motion is denied for those reasons set in the record, and the defendant will be remanded to custody forthwith. That will be the decision of the court. All right. Thank you, everyone.
Thank you, Your Honor.
Thank you, Your Honor.
Counsel, anything else on the record?
No, Your Honor.
Your Honor.
All right.
Take care of it.
Thank you, Your Honor. Your Honor, thank you. Pleasure meeting you too. Thank you. Yeah.